Hi, I am so excited to share with you today the following webinar, Employment Legal Resources for Cancer Patients. Although I'm a lawyer, today's presentation is not legal advice. This presentation also does not establish an attorney-client relationship. Today's webinar is part 3 of a 4-part series supported by a generous grant of the Tower Cancer Research Foundation. This series is called Cancer During COVID because the pandemic has made things more difficult for everyone and can be especially challenging for someone affected by cancer. This is the Cancer Legal Resource Center, and we are a program of the Disability Rights Legal Center based in Los Angeles, California. We help people nationwide for free. We are an education model and we'll do intakes in English and Spanish. We also have a language line for speakers of other languages. All of our services are confidential. People often ask, what does cancer have to do with the law? This is a list of some cancer-related legal issues. Cancer affects the patient, survivor, families, healthcare professionals, and impacts many different areas of the law. If someone has a legal question and is affected by cancer, whether or not the topic is listed here, they can contact the CLRC for more information. The CLRC also has a professional panel, which includes attorneys from across the country who help those with cancer if a caller needs help with a matter in their state and practice area. You saw in the previous slide the practice areas that attorneys handle, but just to recap some of them: landlord-tenant, health insurance matters, medical malpractice, estate planning, employment law, and divorce law. It's a minimal commitment. All that the attorney agrees to is a half-hour consultation, and it's very easy to apply. So if you're an attorney or you know an attorney that might be interested in giving back, helping someone with cancer, this is a great way to do it. I'm going to do my best to leave time for questions at the end of the webinar. Hopefully, I will be able to answer your questions, but if I'm not sure, or if you have questions that come up down the road, this is the best way to get in touch with us, either filling out an online intake through our website or calling our toll-free number to leave a message for someone to call you back to complete an intake. All of the information we provide is free, though we do not provide legal advice or direct representation. We provide legal resources, hence our name, Cancer Legal Resource Center. The CLRC also maintains a library of fact sheets on a variety of cancer-related legal issues on our website, including a resource called our Patient Legal Handbook. The handbook provides a brief overview of many of the most common issues and questions that people living with cancer and their families have. We'd like to thank the handbook's generous sponsors, the American Cancer Society and Breakaway from Cancer. If you're interested in receiving a large number of copies of our handbook, please submit a bulk order on our website. We also have PDFs of the handbook in English and Spanish available to download for free. Our webinars such as this one are always free and cover a wide variety of topics. On your screen is the YouTube link to watch our past webinars. So if you have not seen the previous webinars in the COVID and cancer series, or if you've seen them but would like to check them out and pause on a part if there's a resource you want to write down, or if you'd like to hear what I say again and think about it a little bit more, you can do that on our YouTube link, as you see on your screen. It's very helpful. It's great. You can just pause it wherever you'd like. So you don't have to feel like you have to take notes if I've covered something that you want to remember. But I hope that you'll listen and enjoy this presentation. Today's presentation will focus on your rights at work. And after we discuss the really important fundamental information, I'll also cover COVID-19 related protections that are available if someone loses their employment. Of course, we want someone to avoid losing their job in the first place. So let's start off discussing workplace protections. When someone receives a cancer diagnosis, often this is the first place they may be legally impacted, their job. Our jobs provide us with income and health insurance. So it's important to know your rights in the workplace so that you can protect yourself and have the knowledge of how to ask for what you are legally entitled to. I'm going to explain your rights to take off work as well as in anti-discrimination laws. I'll go over your rights to take medical leave, whether you have a job currently or are wondering about going back to work. I'll talk about anti-discrimination laws that apply to an employee and interviewee and what reasonable accommodations are under federal and state laws. One way I think is especially helpful to learn about these issues, especially when it comes to employment, is to think about a person, a case study. This is a made up person, but I think it's really helpful as an example to help you understand these important concepts. So, this person, John, just found out he needs to have surgery, which means he will have to take some time off. As you can see on your screen, he's a full-time bank manager. All these facts are important. There are 60 employees at John's branch. He's been there 8 months at his job. What are John's options? All right, well, let's take a look at them. I'm not going to hide the answer from you. We're going to discuss a federal law called FMLA. That stands for the Family and Medical Leave Act. It allows qualified employees to take up to 12 weeks of unpaid leave at once or in shorter blocks of days or even a few hours within a 12-month period. This law applies to patients and caregivers of a spouse, child, or parent with a serious medical condition. The caregiver and or patient is often required to get medical certification from a healthcare professional, stating that the caregiver's services are needed. So let's break this down. A person is allowed to take FMLA leave off from work to care for themselves or a covered family member. People that qualify as a covered family member are parents or a person acting as a parent, minor children or adult children who are incapable of self-care because of a mental or physical disability, and spouses. As long as a person is a covered family member, a caregiver can take some time off from work under FMLA to care for them. Not all employers are covered by this federal law. There are employers who are, these are the employers who are covered by this law. As you can see on your screen, private sector employer with 50 or more employees in 20 or more work weeks in the current or preceding calendar year, including a joint employer or a successor in interest of covered employer, a public agency, including a state, local, or federal government agency, regardless of the number of employees, and public or private elementary or secondary school, regardless of the number of employees it employs. Who's covered as an employee? And employees at these companies that I just described must have worked at least 1,250 hours in the past 12 months and must have worked for the employer for at least a total of 12 months in the past 7 years. The 12-month requirement does not have to be all at one time if someone is a seasonal worker, for example. And 1,250 hours averages up to about 24 hours a week. So they must also work at a location where the employer has at least 50 employees within 75 miles. Medical certification. If someone is going to take FMLA leave, it's important to talk to their employer about going on leave. The employee must give 30 days advance notice about the need for medical leave. If the employee learns of the need for leave less than 30 days in advance, which you can understand, especially if someone is facing a cancer diagnosis, then they must notify their employer as soon as possible. Once notified, the employer must notify the employee whether they are eligible for leave under the FMLA within 5 business days. Once eligibility is determined, the employer may require the employee to provide medical certification, which in most instances must be provided within 15 calendar days. In a caregiving situation, the caregiver will need to provide medical certification about the person who needs the caregiving. They also may need to include information that is different from what the patient would have to do. So the Department of Labor has a separate form for family members. And employers, this is really important. We do get this question. They must comply with all applicable laws regarding the confidentiality of medical information. Therefore, the employer must keep the employee's medical information and/or records separate from their personnel files in order to protect their privacy. Again, I just want to underscore this point because we do get questions about employers keeping information private. They have to keep this information separate from one's personnel files. Here's an important tip. If you ask a general practitioner, meaning a doctor that's not an oncologist, to complete the medical certification, their letterhead will not say oncology, and you can avoid disclosing the nature of the illness, of your illness if you're a patient, to an employer if you don't wish for them to know. So that's just something to keep in mind. The next definition I'd like to get into is the 12-week period of job and health benefit protected leave under the FMLA. Now, I know when you read this at first glance, you might be thinking, gosh, do I have to be a lawyer to understand all these definitions? You don't. I'm a lawyer, and I'm going to break it down for you. The 12 weeks of leave can be taken all at once in a 12-week period block of time or in intervals, such as 1 week per month for chemotherapy or every third Friday off for a doctor's appointment. You may use intermittent leave only when it is medically necessary. The employee must provide a certification by a health care provider if the employer requests it. A medical certification would state that working on this different schedule or being able to take leave on an intermittent basis is necessary to provide for treatment or to provide care for or comfort to a family member with a serious health condition. Now, I think it's really important because so many questions that we receive are about specifics. So that's why I'm really going into details about what you could expect. Employers have to calculate FMLA leave using an increment of time that's no larger than how the employer would use to account for use of other forms of leave. So, for example, if the employer calculates leave in blocks of 3-hour shifts, missing most of one shift will count as missing 3 full hours, but may not count as missing a full day of work. So that's an important point because after all, if you or someone you know needs medical leave, sometimes these additional hours, every hour counts and every hour matters. It's important to know that FMLA can work alongside with the American Disabilities Act for someone who's a patient. This happens because after all, someone who's facing a cancer diagnosis may need additional leave. For example, if a patient with cancer took 12 weeks for FMLA leave, but was not ready to return to work, additional leave may be granted as a reasonable accommodation under the ADA, especially if a definite end to the leave is clear. However, taking more time off from work is not always considered reasonable and is decided on a case-by-case basis. Unfortunately, because caregivers are not eligible for reasonable accommodations under the ADA, a caregiver could look to their employer's policies or handbook for additional protections or maybe state laws. And I think this question comes up a lot to the CLRC, where somebody perhaps has a recurrence of cancer. So they're using up the 12 weeks, and in a short amount of time, unfortunately, they have to have additional treatment or follow-up treatment. So the reasonable accommodation can be very useful to consider as an option if someone has used up those 12 weeks of FMLA leave. Now, there's a lot on your screen, but I think this is really just important to see this landscape. FMLA is unpaid. Certain states have paid family leave, so it's important to check with your local government agency to see whether this is an option in your state. The states that do have the program provide partial wage replacement during leave for a limited period of time. These state laws often work in conjunction with the FMLA. It's important to note that being entitled to paid family leave doesn't necessarily mean you're entitled to FMLA leave. And some paid leave programs allow income replacement to take care of family members other than just a parent, spouse, or child. So let's get back to the answer. I didn't forget. I hope you didn't forget the question. Can John take FMLA leave? So let's go back to him. Remember, he works full time for an employer of 60 employers in his workplace, and he's been at his job for 8 months. The answer is no, because he has only been at his job for 8 months. You need to be at your job for 12 months. So there are 60 employers. So does the employer have to provide FMLA to eligible employees? The answer is yes, 50 or more in a 75-mile radius. They're all in his branch. The employer has to provide FMLA for their employees who have met the requirements. All right, so while on FMLA leave, an employee is on unpaid leave, but in some circumstances, an employer may require and employee will have the right to choose to use accrued vacation or paid time off so that he or she gets paid while on FMLA leave. Similarly, an employer may require, and the employee has the right to choose, to use sick leave when the leave is for the employee's own serious health condition. For example, someone might want to use his or her sick time while he or she is out on leave if he or she has no other source of income. So that's something else to consider. Well, what if you know you'll be out for a while? If you don't qualify for FMLA, in John's case and in many others, you're not necessarily out of luck. Or what if you need additional leave time beyond 12 weeks because the 12 weeks is not enough? You might be able to get an extension of leave time. Now, I covered this, but I just want to make sure to go over it again. How? Ask for leave time as a reasonable accommodation under the ADA. I'm going to explain exactly what that is, but essentially, if you qualify for ADA protection, you're allowed to ask for accommodations to help you enjoy equal opportunity in employment. For some employers, it may be reasonable to allow you to take some time off under the ADA. Secondly, check your employer's handbook to see what your company's policy is on sick leave. Some employers have a very generous medical leave policy. That's generally a good starting point. Now, I'm not going to go over all the rules for teachers specifically here, but just to note that there are specific and additional rules if you work for a local education agency, and that's just a heads up. You can fill an intake on clrcintake.org if you have specific follow-up questions about employees of education agencies. So just to recap, as the slide says, FMLA, Family Medical Leave Act, 12 weeks of unpaid job and benefit protected leave. Those are the requirements. If you're not qualified for FMLA, just like John in the example, there's reasonable accommodation requests that you can make or that John can make. And we would suggest that John check out his employee manual. Okay, switching gears here. So hopefully you have an idea of your right to medical leave. I think that's a really important starting point. And just to switch gears slightly, let's move into anti-discrimination laws. I mentioned if you can't get FMLA, you can request reasonable accommodation. So I'll go over that in this section, and job discrimination protection. So people with disabilities cannot be treated differently in the workplace, even in the interview process. I want you to know your rights in the workplace before it's too late. Pass along the information to anyone you think might want to know. It's just important to know your rights so you can exercise them and advocate for yourself to avoid negative consequences and potentially being fired. Unfortunately, people tend to contact us when it's too late. Now, I'm not saying that it's not a good idea to contact us. It always is, even if it's late. But we'd like, and one of the reasons why this webinar is so important is we'd like to provide this information in advance so you have it. We provide these educational presentations to members of the community as much as possible within the hopes that people stop losing their jobs when that could have been avoided. I'm going to go over the American with Disabilities Act. It's the ADA. There are also state laws as well. Now, this is a national webinar, so I'm not going to focus on a particular state. So if you need to know your state's anti-discrimination law and whether it covers employers of less than 15 people, you can fill out an online intake on CLRC's website. So just to explain the big picture, FMLA, the ADA, these are federal laws. These apply nationwide. However, states, meaning your state, can provide additional protections. What does that mean? Well, one example is that it could have a small requirement for an employer, for example, for FMLA. So it's really important to know the national law. That's the baseline, but your state may provide more support in that area, or it may not, but you at least have the federal law. So let's get to it. Employers of 15 or more employees have to abide by the ADA, the American with Disabilities Act. An employee is qualified for protection regardless of how much time you worked for the employer. Remember, in FMLA, you have had to work for the employer for a certain amount of time. So if you have a qualifying disability, as you see on your screen, which I'll explain in a second, and if you're a qualified employee. Now, what does that mean? That means you can perform the essential functions of your job. You might see this in paperwork when you're applying for a job, or you might see this phrasing, essential functions of your job. There's a reason why people use those words. If you need reasonable accommodation to help you do the essential functions of your job, you're qualified. Qualified means you can perform the essential functions with or without accommodations. If there's no accommodation that would help you do your job, then you would not be a qualified employee. For example, a lawyer with a disability who applies for a carpenter's job is not going to be qualified because there's no accommodation that could help the attorney be a carpenter, unless they have some training or expertise that we don't know about. Having been through law school and passed the bar, I know they don't check and they don't train us for carpentry. So, for example, in that situation, the lawyer would not be qualified for the carpenter's job. Okay, so moving along, how do you know if you're qualified for ADA protection? We know you have to be a qualified employee, but you also have to have a disability. It's important to know the definition of disability. Certain laws define it differently. As the slide says, a physical or mental impairment that substantially limits a major life activity. Let's break down the first part of the definition, a physical or mental impairment. Now, what does that mean? Current. If someone is currently having a physical or mental impairment. History. If someone was diagnosed with cancer, has completed treatment, and is applying for a new job, the person is capable of doing the job, but the employer is treating you differently because of your history with cancer. Regarded as, i.e., the employer knows of your diagnosis and starts to treat you differently, even though you're still capable of doing your job and don't have any impairment. Caregivers may be entitled to protection from discrimination based on association with a person with disability. Now, here's an example. For example, caregivers of people with HIV/AIDS. That's an example where perhaps an employer might be discriminating against them because of their association with a person with a disability. So that is not allowed. Now, that substantially limits a major life activity. Now, you don't have to remember all these words, but let's just take a look at it for a moment to see a little bit of what this might involve. So, the physical or mental impairment has to be one that substantially limits a major life activity. These are major life activities. Anything you do to take care of yourself. If you need help doing any of these activities, that is if you have a substantial limitation, which will be explained on the next slide. So, caring for oneself, performing manual tasks, and just as you can see, there's many of them. Concentrating, thinking, communicating, working, major bodily functions. So there are so many listed. Under the ADA, you have to have a substantial limitation on a major life activity, which is the inability to perform a major life activity in the way that an average person in society would be able to perform it. So just to be a little bit more specific, cancer can be a disability under the ADA, but it is determined on a case-by-case basis. Disability is not just the diagnosis/illness itself, but also the side effects from treatment. Now, we know, or if someone has cancer, they know that not all cancers are the same and not all treatments are the same. So that's why it's important to be familiar with one's situation, to have the conversations with your doctor about even before starting treatment. What are the side effects? What will this make it more difficult for me to do my job, and how, and what can I do? What can help me as an accommodation? It's really great to have that conversation. The doctors know because they're familiar with the treatment, and also to be aware of yourself. Cancer is as individual as the person. Not every diagnosis is the same. Not every prognosis is the same. So depending on where you are in the course of your treatment or recovery, cancer may be considered a disability. It's hard to imagine it wouldn't be a disability, but it is a case-by-case determination based on various factors. How severe, how long is the impairment going to last, and how does it impact your life? Now, if you recall just moments ago, I talked about federal law, and then I said it's a baseline, meaning states can go above and beyond. So what does that exactly mean? You can see that I wanted to include all of this information on your screen so you can get a little bit of a sense of just the breakdown. So that was the definition of this disability under the ADA. As I mentioned, you have to know the definition of disability so you know what protections you're entitled to under various laws. There are state laws that provide the same or similar protection to employees. ADA is a federal law, but depending what state you're in, you might be entitled to protection under state law as well. Especially know this information if you don't work for an employer of 15 or more employees. So as you can see on your screen, I just want to point this out, is that some states may include cancer as a disability. In other words, they might even mention it. So this is a question that we do get from time to time, and I think it's such an important one to think about right now. People often ask whether they should let the cat out of the bag. Do you tell your employer about your disability? Do you tell your employer whether you have cancer? Ultimately, and this is the answer that we provide, the decision of whether to disclose is entirely up to you. This decision may be framed differently depending on whether you have a visible disability or a non-visible disability. Some choose to disclose to be fully transparent and eliminate the element of surprise when needing time off later. Others choose not to disclose because although discrimination in the workplace is illegal, the unfortunate reality is that it still happens. Trust me, we get calls about discrimination issues in the workplace. It does unfortunately happen. Consider whether you will need a reasonable accommodation to do your job and whether you may need time off. The Department of Labor website offers some things to think about in weighing your decision, but ultimately it is up to the individual. Okay. If you have a disability and are a qualified employee under federal or state law, You may be entitled to a reasonable accommodation. But what is a reasonable accommodation? An employee might need reasonable accommodation to have an equal employment opportunity. So, a reasonable accommodation, as you can see on your screen, is any change or adjustment in the work environment or in the way things are customarily done that enables an individual with disabilities to enjoy equal employment opportunities. So, ask what might be a reasonable accommodation. For example, if you're a cashier who stands all day for work and experiences fatigue as a symptom of a disability, you may ask for a chair or rest breaks. Accommodations are not always physical adjustments in the workplace. Examples of reasonable accommodation for people with cancer may be flexible or shortened schedule so a worker can rest or keep appointments, working from home for a short time, part-time, or permanently, permission to use the phone to call the doctor, reassignment to a vacant position, or potential leave time or extension of leave time. And we did cover that a little bit. Now, I mentioned working from home for a short time, part-time, or permanently. I'm going to get to the permanently part. I would be very cautious if asking for that, but if it's something that the person needs, it's definitely worth considering. And I want to also take this time to say that due to the pandemic and COVID-19, this aspect of working from home has become a lot more realistic. In other words, before, an employee that might have thought that they felt uncomfortable even broaching the topic of working from home might have been working from home due to the pandemic and not due to their cancer. So I think it's important and in a sense, a very crucial time to have this presentation due to the fact that employees have now, many of them have been working from home. So it might not be as unrealistic of an ask. So, accommodations must be reasonable. That's a very important word. That is, if the employer should accommodate unless it's an undue hardship. As shown in the slide, undue hardship is a significant difficulty or expense in light of an employer. It's case by case for the individual. So let's go back to the cashier who might need accommodation for his or her fatigue. She, for example, or he can ask for a chair, but can't ask for an office and a gold-plated luxury chair. First of all, an office for a cashier is out of the question. Cashiers have to interact with the public and operate a cash register. But the employee is entitled to a reasonable accommodation. A chair is one thing. An executive office chair may not be the right accommodation. The employer can say a stool would be best because they need something that takes up less space, etc. So it is an interactive process. The employee may request a reasonable accommodation. The employer may give feedback and say what they can and cannot do, and the employer may have additional things to share, and then the employee might make an additional statement or request. So hopefully there can be a resolution. Remember that employers must make reasonable accommodations. If you need time off and you're not eligible for FMLA or don't have any leave time, you may want to ask for time off as a reasonable accommodation for someone with a disability. Or if you're coming to the end of the 12 weeks allowed under FMLA, as I covered before, and your doctor says you shouldn't go back to work yet, then you might ask for additional time off or an extension of FMLA as a form of reasonable accommodation. If your doctor says you need another week to heal and you ask for additional week, that might be reasonable to ask of an employer. It's not necessarily a guarantee you'll get what you ask for if it's a few days or a week, but much more likely to be considered reasonable if it's shorter time. This is important what I'm about to say. If your doctor says, I'm not sure when you'll be able to go back to work, but it probably won't be in the next few months, and you ask your employer to hold your job open for months or just indefinitely, then are they going to see that as reasonable to hold your job open for such a long period of time? Probably not. What if your employer says, stay out as long as you want, your job will be here? Be aware that even if someone says that, and I want to underscore this point, At some point, it could become unreasonable for them to hold your job open. So even if you have an employer that literally says stay out as long as you want, people have had employers suddenly change their minds. Know your rights as far as leave time goes. We have a handout on our website that explains the difference in medical certification that may be required for FMLA versus ADA reasonable accommodation. The employer may request documentation of a disability if there is a request for accommodation, but the employer must keep this documentation confidential, and the employee does not need to specify cancer as a disability. So, under the FMLA and ADA, do you need to disclose your specific diagnosis? No. As long as documentation establishes the employee has a disability under the ADA and needs a reasonable accommodation. Under FMLA and the ADA, the employer can ask the employee to get a second opinion. But under FMLA, the employer may only do so if the employer has reason to doubt the validity of the medical certification. Under the ADA, the employer can ask the employee to get a second opinion if, again, the certification is not credible or if the employee fails to correct deficiencies. The employer would have to pay all costs associated with getting the second opinion. Our website, meaning the CLRC's website, has a handout that explains all the nuanced rules in detail and compares the FMLA and ADA rules for medical certification. I think it's definitely a really good idea to go over some of these details. So not that you have to memorize them, but just to be aware so that if you look for this information further in the future or want to learn more, you're at least a little bit familiar and have heard it before. So looking for a new job, that happens. Someone wants to go and work somewhere else. Job applicants have rights under the ADA. We've talked a lot about workplace protections while you have a job. I want to talk for a moment about job applicants. An applicant with a disability, like other applicants, must be able to meet the employer's requirements for the job, such as education, training, employment experience, skills, or licenses. An applicant with a disability must be able to perform the essential functions of the job, the fundamental duties, either on her own or with the help of a reasonable accommodation. An employer does not have to hire you if you're unable to perform all the essential functions of the job, even if you have a reasonable accommodation. However, an employer cannot reject you only because the disability prevents you from performing minor duties that are not essential for the job. If you're looking for a new job and have had a history of cancer, you may be wondering, such as, can a job application contain medical history questions? Or what should I tell my prospective employer regarding my cancer diagnosis? Or what can I keep confidential? Well, let's get to the answer. You never need to disclose to your employer that you have a medical condition unless you're asking for a reasonable accommodation or some type of medical leave. The ADA prohibits employers from asking questions that are likely to reveal the existence of a disability before making a job offer, meaning the pre-offer period. That includes written questions and inquiries during interviews, after an offer has been extended, but before the individual begins work, meaning the post-offer period. An employer can ask questions and ask an employee to take a medical exam as long as the employer asks those questions to everyone, not just you, but everyone who's offered the same type of job. They can't only ask it to people who have obvious disabilities. So keep in mind that national and state laws are just the baseline for protection that employers must provide. Sometimes employers provide more protection than the law requires. The places you can look for additional workplace protections include employment documents like employee manuals or union contracts. That is, if you're a part of a union. That's the last part. Check with people like your human resources representative or a union representative if you're a part of a union. I say this because a lot of people get an employee manual and don't look through it. And I understand that. But the employee manual may have some very useful information. It's at least worth that to read it. All right, so we did a case study before. Now we're going to do a case study again. Let's give an example here to put it all together. Now, just to be clear again, this is not an actual person. This is a person we created for the purposes of this presentation. Sarah recently graduated from college and has been working part-time at a law office for 2 months. 2 weeks ago, she was diagnosed with cancer. Last week, Sarah told her supervisor that she had been diagnosed and will need some flexibility to get treatment, meaning she'll need to have some time off. Does she qualify for ADA protection? Now, before I turn the slide, think for yourself for a moment. She's only worked for 2 months. Does that matter? No, not for the ADA. As you remember, and I discussed this, anti-discrimination law even applies during the interview. She can ask for reasonable accommodations, chair, asking for nap breaks, asking to take some time off, asking to work from home. Pop quiz for review. Would FMLA apply? Sarah worked at the company for 2 months part-time. She can't get FMLA because she hasn't worked for over 12 months and hasn't worked 1,250 hours this week. The employer, for example, is 50 plus in a 75-mile radius, does have 200 employees. A reasonable accommodation could be an extension of leave time, however. So, as shown in this slide, this is a key part of this. Having a disability doesn't entitle someone to indefinite protection. It doesn't mean you can automatically cannot be fired for any reason. All it means, and this is really important in order to understand the law, is that you can't be fired for discriminatory reasons. You can be fired for performance-related reasons. This is why we tell people to ask for accommodation before your performance is affected. If an employer sees you sleeping on the job, you can be fired. If you tell your employer that you have a disability that causes fatigue and you'll need to take frequent breaks or work less hours, then they have to engage in the interactive process to come up with an accommodation. Now, it doesn't mean you'll get everything you ask for, but it might mean you get something. Once you tell your employer you have a disability, they're on notice and will need to work with you to come up with something to help you. What happens is a lot of people don't want to tell their employer out of fear. Then they slip up at work and can't do what they once did to the full extent, and they're terminated. Saying, wait, but I have cancer, after you're terminated doesn't do anything for you. Now, we are the Cancer Legal Resource Center, so of course I'm going to provide you with some resources. Now, like I said at the beginning of the presentation, you don't have to jot this down. You might. I'm going to pause for a moment, but this webinar is being recorded, so it will be available for free on our YouTube site. You can move to this part of the presentation, pause it, and take down the information. Now, let's talk about COVID-related protections. These protections, I want to be clear, are not just for those affected by cancer, but there's been a lot of information out there related to pandemic protections. So I wanted to talk about some that are related to the workplace. So the American Rescue Plan Act it extends tax credits until September, and this is as of the date of this recording, because after all, at any point before or after September, there might be an extension or additional protections. So as of the date of this recording, for employers who voluntarily provide what was the previous type of leave, Family First Coronavirus Response Act leave. So 2 weeks of paid sick leave at the employee's regular rate of pay if the employee is unable to work due to having COVID-19, because after all, someone with cancer can still get COVID-19, or 2 weeks of paid sick leave at 2/3 rate of pay if the employee can't work due to caring for a child whose school is closed related to COVID-19. So this is not a requirement for employers to provide, but an employer will provide tax credits. So your employer may have an incentive to offer it. Let's talk about another COVID-19 related protection. There are additional qualifying reasons for paid leave. For example, someone can get up to 80 hours of paid sick leave at the employee's regular rate of pay, where the employee is unable to work because the employee is quarantined and or experiencing COVID-19 symptoms and it's seeking a medical diagnosis, or 2 weeks up to 80 hours of paid sick leave at 2/3 the employee's regular rate of pay because the employee is unable to work because of a need to care for an individual subject to quarantine. So also, related to the vaccination, a person may need to take some time off. So unemployment, unfortunately, people do lose their jobs. So unemployment insurance payments are based on how much someone made before they were laid off. The more someone made, the more they collect in unemployment insurance, up to a certain amount, of course. The most someone before could be paid is $450 a week. But the federal pandemic unemployment compensation program adds additional money on top of whatever employment benefit someone is receiving. This additional money is currently $300 a week. So someone could now get up to $750 a week total, $450 max, plus the additional $300 a week. Before the pandemic, one could collect unemployment benefits for up to 26 weeks. The pandemic emergency unemployment compensation extends that to 74 weeks. Before the pandemic, independent contractors, business owners, and self-employed people were not eligible for unemployment insurance. But under the pandemic unemployment assistance, these types of workers who lost their income because of the pandemic can now receive unemployment benefits, and this is now extended to 74 weeks. So I just want to mention this because after all, someone who has cancer could lose their job, and it's important to know what the protections are out there as a result of the pandemic that might be helpful. And I wanted this to be a one-stop shop for information related to employment issues for someone affected by cancer. So, under the Consolidated Appropriations Act of 2021, the Mixed Earner Unemployment Compensation, or MEUC program, was created. Basically, if someone works as an independent contractor and an employee and they lose both jobs, they can get unemployment for the employment job, as we just discussed, and they can also get $100 on top of this to cover unemployment insurance for the independent contractor job. This program is for people who earn at least $5,000 in self-employment income in addition to regular W-2 wages. So, to be eligible, one must be already receiving unemployment insurance, but not be receiving payments under the Pandemic Unemployment Assistance Program. So, just to be clear about that. We are wrapping up this presentation soon, so I want to make sure that you have some COVID-19 related resources. These are all important to have at your disposal if you'd like. And Again, it's a lot on your screen. You don't have to take it all down. I'm pausing for a moment if you'd like to jot something down in the event that you need it immediately, but this will be available as part of the recorded presentation on our YouTube site. And you can go straight to this or pause on this page for as long as you'd like. Now I'm going to show you some employment-related resources. And as you can see on your screen, there's a website and a resource called Cancer and Careers. They provide helpful information. We also oftentimes will share information from the EEOC, the American with Disabilities Act webpage, and the Job Accommodation Network. So I'm going to pause for a moment in case you need to take down information and get your questions ready if you have them. I will be stopping recording when I do answer those questions, but I'm just going to give you a moment to write down these websites if you want. Again, this will be available since this presentation is being recorded. Your questions will not be recorded, which is why I do stop the recording to answer those questions. So thank you for participating in this presentation. I know your time is valuable, and I'm so grateful you spent this time with me to learn. Please remember that if you have any questions that are specific to your situation, you can either call the CLRC or fill out an online intake form, and we will get back to you. You don't have to do both. If you do either the phone call or the online intake, that is enough. We will get to you, and we will either complete the intake on the phone if you've called and left a message, or if you complete the intake online, we will see it and get to work to help you. Both of them are free and confidential. So right now, if you give me just a moment, I will stop the recording and take your questions. We have actually about 8 minutes left, so that is plenty of time, hopefully, to get to your questions. And of course, if you'd like to ask a specific question, or if I don't get to your question today for some reason, either way, or if you'd like to ask a follow-up question, in addition, and I've answered some of your question, please contact the CLRC. And I will now press stop to recording. Thank you so much for joining me today. This was fantastic to have you here with me.